we have a question from Michelangelo, who's asking, will the new prevailing wage can be a grounds for the 221G? Chris, maybe let's take a step back on Michelangelo's question. Can you talk a little bit about the updates on the prevailing wage situation?
So I think the first thing to understand is that actually the prevailing wage rule did not change at all. And I think that's a misunderstanding amongst, frankly, some lawyers, some companies, some nurses, and actually the embassy officials themselves. The prevailing wage rule did not change at all. The only thing that changed is that when the Department of Labor seeks to certify a prevailing wage, the Department of Labor has a choice of using any survey it wants to decide what that wage is. And the Department of Labor always chooses something called the Department of Labor's OES survey. But it is possible, and it's completely legal, and we do it in our office as well, to use an alternative survey from another company. The only thing that happened a month ago is that the way that the US Department of Labor computes that OES survey changed such that it's raising wages between, I don't know, 25 and 40%, depending on the job and the location, something like that. So, number one, the prevailing wage rule did not change. One of the surveys, which is the most dominant survey, changed the way it computes, okay? Now, we have seen in our office over the last month since this new rule came in, that a lot of the embassies are misunderstanding and they think the prevailing wage rule changed when in fact, and I know I'm repeating myself, but I think it's important, when in fact the prevailing wage rule did not change. The way the OES survey is computed changed. We have at our office, off the top of my head, Abu Dhabi, Manila, London, Singapore, at least those 4 posts, there may be several others, that we have been educating those posts the difference between the prevailing wage rule and the OES survey. And we are slowly starting to see, especially in Manila, that the embassy is starting to understand the rule. And so will you, to specifically answer the question then, Tanya, will you get a 221G over the new prevailing wage? Perhaps you may, but it's being incorrectly issued by the post. And so you should work with your company and your company's attorney to write a letter to the post explaining the difference between the OES survey and the prevailing wage rule. So that's the situation. The next piece of this that is information more generalized is that there are 3 different lawsuits here in the United States, one in Northern California, a few hundred miles north of where Carl's sitting right now, one in Washington, D.C., and a third one in New Jersey, which are all challenging this rule because it's the belief of most immigration attorneys that, and some very big companies and some very big colleges in the United States, that this rule was improperly put forth by the Trump administration. So there's 3 lawsuits. They are all having their hearings between Monday and the 23rd. So there's about a week or 2 period there where all those cases are going to be heard. I have heard a rumor that the first of the 3 cases, they're not going to have a hearing. And so there is some belief that the reason they are not going to have the hearing is because the case is so clearly favorable against the government and so favorable for the folks who are challenging it. If any of those cases are successful, it would probably mean that the rule that was put out changing the computation of the OES survey would go away. But I think the important thing for you guys to realize is you may get a 221G. The longer this goes, you probably won't get a 221G because we are educating the posts.
Okay. And thank you for that very detailed explanation, Chris, because I know this is very confusing to a lot of people. And I think the biggest takeaway just from my side, Carl, and I don't know what your feelings are on this particular topic, but I think it's really just important for anybody when you are, when you are making a decision of which client to go with, which offer to take with, is to make sure that you're dealing with a company that understands international recruitment for nurses and make sure that you are with a good attorney who knows and understands and specializes in nurse recruitment, like some of the lawyers on the panel, because these things change all the time. As Chris has said, there's lawsuits, it might change again. It's a fluctuating situation, and it's really important just to try and educate yourself about that process. Carl, do you have any other thoughts about this particular situation?
Yeah, well, there's been a presidential election and an election for Congress in the U.S. A little over a week ago. And so we're expecting that come January, a lot of these rules, like the prevailing wage rule and hundreds of others that have been restricting immigration to the U.S. will disappear, because it won't require an act of Congress. It'll just be a presidential proclamation. So I mean, we're in the middle of November right now, and so January is only maybe 8 weeks away. So I wouldn't worry about these temporary things. I think most of them will go away come January.
Okay. And that brings me to the next question. And I just want to also just say, before I move to the next question, that I just want to be clear that I know that a lot of people, we've just been through an election, as Carl mentioned, and a lot of people have strong opinions on both sides. And from the panel's perspective, as well as I know the LaFora admin, Louise and Paul, and people on the LaFora admin, the important thing is that this is not a place, we are not expressing personal opinions. At this stage, or taking sides, this is really just about looking at facts and how this might influence immigration.